First is the question on timing, motive of the bill. Some suggestions that we are rushing this, that what is a rush? Does it have to do with Benjamin Lim? Are we chasing shadows? And so on and so forth. Are we chasing shadows? Former Chief Justice Chan Sek-Keong said in an interview 5 years ago that scurrilous remarks, unless firmly dealt with, would inevitably undermine public confidence in the judiciary. And what has been the timeline for this bill? This was first raised by Chief Justice Chan in 2010 in his opening of legal year speech, where he said that he had asked me to consider enacting such a law. In May 2012, I stated that the Ministry of Law intends to put the law of contempt in statutory form and was working on a draft bill. Attorney General Stephen Chong said in opening year legal 2013 that the ministry was working with the AGC on the bill. Indeed, there was no rush, and this bill has taken longer precisely because there was no rush. Why? And I suspect I'll be making this point numerous times. The law is already there. The law of contempt is there. There is no urgency at all. There is only one change in terms of scandalizing the court from real risk, it's come down to risk. Otherwise, the other three hits are exactly the same. Please note that. The way it is set out is exactly this. The law tomorrow, if the bill is passed into an act, will be exactly the same as the law today in terms of the hits of contempt, except for the test in scandalizing the court. Why are we putting it in writing? I have explained numerous times in my opening speech, and really the question is whether you accept it or you don't accept it, but the Hansard record is there. I said it in 2012, I said it in 2013, Chief Justice Chan Sek-Keong said it in 2010. So if you want to put up a conspiracy theory, I think you've got to try harder. And we normally take 6 years. The reason we didn't push on with this bill is very simple. As I said, even in the absence of the bill, the law is there. But it's just that it's better for it to be in writing because it's criminal law. It's the only criminal law that's not set out in statute. So at some point, we have to set it out. So all these suggestions of democracy under attack, we are going to restrict freedom of speech, makes for fine statements outside if you believe that you can mislead the public. But for a real debate, it doesn't meet any of the points that I've made. So it really questions whether the speeches here are meant for a real debate in a first world parliament, or they are made for consumption outside in the belief that the public can be misled. And as for what I said about the bill when it first came out, on July 11, I have said that the bill clarifies and crystallizes process. The law remains broadly the same. I say that today too. Now, Ms. Lim, I think maybe Mr. Goh, Associate Professor Daniel Goh, asked me what sort of consultations were conducted. Well, we spoke with the judiciary in extenso. We took in their comments. We spoke with the Law Society Council. We spoke with groups of lawyers. We spoke with the academia. We spoke with media. We spoke with some others. But in underlying it all, the fundamental point to remember is when looking at this bill, tomorrow, Tuesday, assuming the bill gets passed into act today, the law is essentially the same. Some processes, additional processes are there, but the law is essentially the same. I say that and look anybody into the eye and say that. If anyone says that's not true, tell me. And we took into account the feedback received before the first reading of the bill, and I have to say we made a number of amendments based on the feedback. As regards what was set out by REACH, the article published on REACH invited readers to share their views on the bill, but a number of consultations had taken place before the first reading. Mr. Lau made a fairly impassioned speech, but I have to say the entire speech seems to be based on a misunderstanding of what the bill is all about, because everything you said is factually untrue, and I'll explain why. You raised the specter, ordinary citizens sitting in coffee shop talking will be charged with contempt. Does one honestly believe that? How does ordinary citizens sitting in a coffee shop having a beer and talking about a case pose a real risk of prejudicing any proceedings? Does anyone believe that? If the law today, the law yesterday is the same as the law tomorrow, have you seen anyone being charged for sitting in a coffee shop and talking about cases? You know, I think we want a debate that engages honestly on the facts. I'll tell you when someone sitting in a coffee shop discussing a case could be contempt. If you catch hold of a witness, have a beer with him, and try and influence him or threaten him in a coffee shop, that will be contempt. But if you sit with your friends and talk to them about a case, how do you think it impacts on any case? Give me an answer, somebody. Let's get real. Mr. Lau also said, government can say whatever it likes. And the courts can't do anything. Completely untrue. Under our system of law, the courts are the final arbiters of any provision of the law. The government has got to act in accordance with the law. Mr. Koch, Ms. Quick, Associate Professor Mahadevan, others asked me. I confirm that. What Justice Chur Singh said, if a minister stands up and speaks about a particular case in a manner calculated to prejudice the proceedings, and if he does it in bad faith, then I think he will be committing contempt. And the Attorney General will be entitled to commence proceedings. Again, in real terms, what that subclause provides is no different from what is happening today and what has been happening all along. Let me give you examples. I told you about bank runs. I told you about hospital incidents. The last hospital incident, there was an inquiry. The government came out and made statements. At that time, it was entirely possible. In fact, coroner's inquiries are going to take place. But nevertheless, the government came out and made statements. Did anyone here think that that was wrong? Does anyone think that the government should not make those statements? Would it be tenable not to say anything? Let's take a different example. Let's say a couple of people get killed in an accident involving a public transport company. There will be legal proceedings. But can the government wait until then to come out and say what it knows, what has happened, what actions it has taken? What, we just keep quiet? Few people die and nothing is said? Is that the way government can function? And government statements are carefully drafted with advice from the Attorney General to try and not to prejudice ongoing proceedings. And this has been going on since time immemorial. In Lau Sui Song's case, the statements were a little bit more direct than the usual government statements. But I confirm for the record, the courts are the final arbiters. They have to be the final arbiters if the rule of law has got any meaning. Whatever a minister says, whatever a government agency says, ultimately you apply, you look at the clause, and you see whether the statement comes within the clause. This was specifically discussed between us and the Supreme Court, and I put that on record. So it makes great buzz when Mr. Lau says, all the people in the coffee shop, they are all now going to commit contempt. Ordinary people, whereas the government can say what it likes. Untrue and untrue. There's a third point Mr. Lau makes. In the whole process, the courts have become an assistant to the government. Untrue again. The Attorney General, if he believes that there is contempt committed, today has to apply to charge the person. That means he says you have committed an offense and he charges you. This law, in fact, allows greater flexibility. What it says is you don't have to charge in every single case. Instead of charging, what you do is you go, you apply to the court, and you try and persuade the court that there is contempt and the person should take it down. Who is the boss? The court is the boss. The court decides whether or not the Attorney General satisfies the court. And if the court disagrees, it tells the Attorney General, go away. Now, second, he gets the order. He serves it on the person who has published. The person who has published is not happy. He can go back to court and say this is not contempt. Who decides? The courts decide. So please, let's not misrepresent the bill. We can have disagreements on points of principle, judgment calls, but let's not go out and say things which are completely inaccurate about what the bill does and doesn't do. Dr. Tan Wu Meng asked me about government making statements and whether it is subject to court. Dr. Tan, yes, I think you heard me. Mr. Leon Pereira made an impassioned speech, great danger to freedom of speech, rush to legislate. I didn't know you would consider 6 years to be a rush to legislate. It is slow by our government standards. Substantially affects public debate. Are there any cases where witnesses have not come forward? Why change? Why do you assume there's a change? Your entire speech, Mr. Pereira, with respect, proceeds on a fundamental misunderstanding of what this bill is about. This is your logic. This bill has been put in to curb freedom of speech. You have rushed it this year. You are trying to curtail freedom and you're trying to do it by stealth. And as a result of this, tomorrow democracy is going to be much poorer, with respect. All untrue. Why? the law tomorrow is going to be pretty much the same as it is today on contempt.